Welcome to the fifth session in our series of coffee break webinars. For those of you who haven't tuned in before, I'm Elaine Brailsford and I'm joined by my colleague Stephanie Hepburn. We're both members of Shepherd and Wedderburn's Rural Disputes team. This week we're going to be talking about the right to roam and the vexed issue of e-bikes. I think the most common query we've been asked by clients over the last few months is about exercising the right to roam.
Must be a lockdown thing.
I think it must be. So today we're going to look specifically at what can be done when access takers are exercising the right to roam using vehicles such as e-bikes and quad bikes, and what remedies are available for trespass or unlawful exercising of the right to roam. So to start us off, Stephanie, will you just briefly recap on what the right to roam is?
Yep. So as you'll know, the Land Reform Scotland Act 2003 gave everyone in Scotland rights of access over all land and inland water, unless the land is excluded. And these rights are often referred to as the right to roam. They do on the face of it appear to be quite extensive, but they're subject to many restrictions. The right to roam can't be exercised over land to the extent there's buildings on it, so a fixed bit of machinery and anywhere that provides an individual with privacy or shelter. So that would include tents, caravans, residential and non-residential buildings. Gardens around houses, caravans and tents are also excluded, and the extent of land excluded is what is required to allow a reasonable degree of privacy. We had a query recently about some of Edinburgh's private gardens, these ones in the new town, where communal gardens are separated from the actual houses, and you have to have a key to access the garden. But to the extent that those gardens are owned in common, the right to roam doesn't apply to these types of gardens. Schools, playgrounds, sports or playing fields are also excluded, as is land on which crops are growing.
So as you probably know, the public must act responsibly in exercising their right to roam, and the Scottish Outdoor Access Code gives guidance on what behaving responsibly means, both for land managers and for those exercising the right. The right to roam allows the public to be on or to cross land for recreational purposes, carrying out relevant educational activities, and limited types of commercial activities. It's not permissible to use the access right for certain types of conduct, such as hunting, shooting, fishing, or for the purpose of committing an offence. The right to roam does not apply to motorised activities, and we will come to look at the actual legislative provision in a moment. But basically, activities like off-road driving or motorbiking will not be allowed unless, of course, you've got the landowner's permission. And the landowner is not obliged to give you that permission. The only exception to this is somebody with a disability. They may use an adapted vehicle to enable them to exercise their right to roam. The motorised activity exception gives rise to the vexed issue of whether you can exercise the right to roam using an electric pedal bike or an e-bike.
So e-bikes have become increasingly popular in recent times due to, I guess, they're environmentally friendly and a relatively easy mode of transport. I've not actually been on one, but I think that electric bikes do look quite similar to ordinary pedal bikes. And I think the speed of the motor on an e-bike can also be limited, but therein lies the grey area. E-bikes do have a motor, so does that automatically exclude them from the right to roam? So if you look at the exact wording of the provision in legislation, and I'll put this on the screen, bear with me, it has to load up. So that should be the provision there.
Seniors over 65 who've been on Medicare or Medicaid for more than 3 months, you were supposed to get $3,000.
So what that says is, Section 9F of the Land Reform Scotland Act says that land, you can't use the right to roam whilst being on land in or with a motorised vehicle or vessel, other than a vehicle or vessel that's been adapted, as Elaine mentioned, with the exception that she mentioned earlier on. So that provision seems quite clear. you can't cross land on a motorised vehicle. So that would clearly exclude quad bikes. But e-bikes have got a motor. So are they a motorised vehicle? And that takes us to consider what a vehicle in this context actually is. It's not actually defined in the legislation. So you've got to look at what its ordinary meaning is. And as a bicycle as a means of transport, it is regarded as a vehicle. So I think then on a strict construction of the right to roam legislation, which classifies vehicles as either motorised or not, you might conclude that you can't actually exercise your right to roam on an e-bike without the landowner's consent.
But here's the thing. If a bike meets certain requirements that mean it's an electrically assisted pedal cycle or an EAPC, then it's classed as a normal pedal bike under the road traffic legislation. You don't need a license to ride one. It doesn't need to be registered, taxed, or indeed insured. An EAPC's treatment as a normal pedal bike arguably means you can ride it on cycle paths and anywhere else pedal bikes are allowed. The criteria for what is an EAPC are found in Regulation 4 of the Electrically Assisted Pedal Cycles Regulations 1983. An EAPC must have pedals that can be used to propel it. Its electric motor must have a maximum power output of 250 watts and no more. It should not be able to propel the bike when it's travelling to more than 15.5 miles per hour. It must show either the power output or the manufacturer of the motor. It must also show either the battery's voltage or the maximum speed of the bike. The 1983 regulations and the 2003 Act are two completely separate pieces of legislation. For the purposes of road traffic law, it may be classed as a pedal bike, but under the 2003 Act, it seems caught by the reference to motorised vehicle. Mm-hmm. Now, each statute must be construed according to its terms. So there's nothing repugnant about different meanings for the same object in different acts that have different purposes.
Well, the National Access Forum, which was set up to advise on national issues linked to Scottish access rights, did look at e-bikes back in February 2016, and they concluded that if an e-bike, which meets the EAPC criteria, is not regarded as a motor vehicle for the road traffic legislation purposes, then they shouldn't be regarded as motor vehicles for the right to roam legislation. And that, I think, that position has really become the accepted view, but that conclusion hasn't been tested in the courts. And as Elaine said, you can't just simply assume because the road traffic legislation reaches that conclusion, the Right to Roam Act would do the same. After all, the Right to Roam legislation does explicitly exclude motorised vehicles, and e-bikes do have a motor. The English legislation that deals with public rights of way, which is the Countryside and Rights of Way Act 2000, that explicitly removes EAPCs from a definition of a mechanically propelled vehicle. So in England, you can use an EAPC to exercise the public rights of way, but unfortunately it's not so clear in Scotland. Just last year, the National Access Forum looked again at e-bikes and released a new discussion paper of e-bikes and their use in the context of the right to roam. And we understand the Scottish Outdoor Access Code may be being revisited. But of course, that code isn't law, it's just guidance. And in our view, the matter does require judicial interpretation. If the government didn't like the outcome of a case that litigated what Section 9F exclusion was, they would have to amend the 2003 Act.
So we're calling on all of you that want this to be judicially determined to give us a nice little instruction so we can test it.
Nice plug there,
Just for completeness, we should say that the right to roam is very different from a public right of way. And we find a lot of clients do confuse the two. Public rights of way are formed by people using the same route for a number of years without challenge and conditions are met. The public right of way only extends to passage, but unlike the right to roam, passage by motorised vehicles is allowed. Now, looking at remedies, what if you find someone illegally taking access over your property, such as in a Land Rover or quad bike? Stephanie, what what are you going to advise would be the options for the landowner?
So it used to be said by many people who thought they were in the know that there is no law against trespass in Scotland. You heard it all the time, but that never totally was correct. It's not a crime to trespass, but it is, putting aside the right to roam, a civil wrong. Trespass is just temporary intrusion into land owned by somebody else, but if you're lawfully and responsibly exercising your right to roam, this won't amount to trespass. And Section 5.3 of the Right to Roam, the Act, says that the exercise of access rights does not of itself constitute trespass. So that really means that a landowner won't be able to take action against someone exercising their right to roam responsibly over land that the Act applies to. But if someone's taking access on, say, a Land Rover or a quad bike, this will amount to trespass, because this is not something you're allowed to do to exercise your right to roam. Similarly, walking over someone's private garden. So if that garden is land that's excluded from the scope of the legislation, that too will be trespass. I had a case like that recently where land was excluded from the right to roam because it was garden ground, but one particular person continued to cycle over a path that ran through my client's garden. The remedies for trespass are interdict, and if the land is damaged, compensation. Interdict is the Scottish equivalent of an injunction, and it would prevent the unlawful activity from carrying on in the future. The difficulty, though, with interdict is you can't interdict the public at large, so you have to know who the perpetrator is. In the case that I mentioned a second ago about the cyclist, because we knew who he was in that case, we were able to write to him and say if he didn't stop, we'd be looking to interdict him. So if the access takers who are trespassing can be identified, then interdict may be the appropriate option. But if not, it's very hard to do anything meaningful via the courts, and would then look to more practical ways of stopping the unlawful activity. It's also worth saying that whilst interdict may be the appropriate remedy for trespass via the courts, it is a discretionary remedy, so it's open to the courts to refuse to grant it. There must be an apprehension the trespass will occur again. The courts must be satisfied of that, because if there's not a reasonable likelihood of trespass in the future, then there isn't anything to interdict. The landowner is also expected to have given a warning to the trespasser and to monitor its effect before seeking the interdict. Interdicts won't be granted if the trespass is trivial, so there must be at least an appreciable wrong. And also, I think since trespass is by its nature temporary, it's often vulnerable to arguments based on triviality. There was an interesting case back from 1885 in the sector which demonstrates this. Winans against McRae. It was a case where the pursuer sought to interdict the defender from putting any lambs, sheep or cattle or other beasts on his lands to graze. The pursuer was a tenant of 7,000 acres of unfenced rough grazing, and the defender inhabited a cottage adjacent to the pursuer's land. But in that case, the only animal which the defender was proved to keep was a pet lamb. So you can imagine, interdict was refused by the court, and the judgment, there was quite a lot of scorn for the pursuer's stance in that judgment, as you can imagine. So triviality does come into it. That's a pretty extreme example, but it does show that interdict is more suited to some types of cases more than others. I think it's best suited probably to a case of a persistent and known trespasser, for example, a neighbour who habitually might use a shortcut over your land, but it's perhaps less suited to trespass by the public at large.
And can an estate owner just put up a gate then and stop this?
Well, good question. It depends what type of gate or fence is being proposed. Self-help remedies like this are often the most effective remedy where there is trespass, and the self-help remedy is often designed to prevent or discourage trespass. So like you said, putting up fences or gates. That's perfectly lawful as long as it doesn't obstruct legitimate access takers. So Section 14 of the 2003 Act prohibits signs, notices, obstructions and the like that haven't got any other purpose except from restricting the access rights, and that also allows the local authority to serve a notice requiring any obstructions to be removed. So a gate or a fence or a wall that prevents all access won't be allowed, unless, of course, the land itself is completely excluded from the right to roam. If you've got a gate that still allows the access takers, including cyclists, those with buggies and horses, but prevents motorised vehicles, that would be permitted. Putting up signs reminding access takers of the responsibilities is also a good idea, as long as that is not seen as a deterrent.
Mm. And what about damage that's caused? You know, you've got the teenagers on the motor quad bikes going over your land. What can you do about that?
Oh, yeah, so the issue is the same. It's really identifying who the perpetrator is. So if you know who they are, then yes, compensation may be sought, but you still got to establish a loss, a quantifiable loss. So we'd have to look at whether the damage has caused any loss that we can quantify. So that could be diminution of value, damage to crops, loss of profits maybe. Depends on the circumstances.
Okay. Well, time's up. That concludes our short webinar on the right to roam and motorised vehicles. As with any disputes, the right answer to that vexed question about e-bikes can only be determined ultimately by the court. Stephanie has put some more detailed notes and information up on the screen about the right to roam.
There should be a resources tab, so you should find them all there, the resources on the tab.
There's a link to a more in-depth two-part webinar that we ran last year on access rights. We're back next week. I hope you'll join us. 1st July, we'll be having a look at common family farming partnership problems and how best to resolve disagreements amongst partners. But for now, thanks for joining us.
Thank you.